So on August 26th, the United States Supreme Court invalidated the CDC's Eviction Moratorium. If you were a tenant in a high COVID area, the CDC had issued an order that you could not be evicted. And so this enabled lots of renters to survive the pandemic by not having to be evicted if they couldn't pay their rent. I'm sure there was somebody who didn't pay their rent because they couldn't be evicted, and it gave some relief to a lot of tenants. Of course, that relief was often on the backs of the landlords, which I know that there's a tendency to assume that landlords are evil people. It's an easy picture to get. I've been a tenant before, and landlords were always pretty oppressive. So it's easy to be against landlords, but I do want to say landlords are people too. And there can be good landlords and there can be bad landlords. And whether they're good or bad doesn't mean that it's okay to not pay your rent. Sure, people lose their jobs from the pandemic. There were some programs put in place for rental assistance, for paycheck protection programs. The landlords could probably apply for relief as well. So hopefully everyone got through it and the situation wasn't as bad as it would have been if there were no protections in place. But the Supreme Court has now invalidated that. Let's take a look at what they have to say. In March 2020, Congress passed the Coronavirus Aid, Relief, and Economic Security Act to alleviate burdens caused by the burgeoning COVID-19 pandemic. Among other relief programs, the act imposed a 120-day eviction moratorium for properties that participated in federal assistance programs or were subject to federally backed loans. So it wasn't an eviction moratorium on properties that did not participate in federal assistance programs or federal loans. When the eviction moratorium expired in July, Congress did not renew it. Concluding that further action was not needed, the CDC decided to do what Congress had not. The new administratively imposed moratorium went further than its statutory predecessor, covering all residential properties nationwide and imposing criminal penalties on violators. The CDC's moratorium was originally slated to expire December 31st, 2020, but Congress extended it for 1 month as part of the second COVID Relief Act. As the new deadline approached, the CDC took matters into its own hands again, extending its moratorium through March, then again through June, then again through July. The CDC relied on Section 361A of the Public Health Service Act for authority to promulgate and extend the eviction moratorium. That provision states, "The Surgeon General, with the approval of the Secretary of Health and Human Services, is authorized to make and enforce such regulations as in his judgment are necessary to prevent the introduction, transmission, or spread of communicable diseases from foreign countries into the states or possessions, or from one state or possession into any other state or possession." This would be similar to the Interstate Commerce Clause. Although this isn't necessarily interstate commerce, the federal government has purview over things where the states interact, but not necessarily within the states themselves, except for certain enumerated powers in the Constitution. So foreign entry and interstate entry are much more in the purview or power of the federal government than telling any one state what it can do intrastate. For purposes of carrying out and enforcing such regulations, the Surgeon General may provide for such inspection, fumigation, disinfection, sanitation, pest extermination, destruction of animals or articles found to be so infected or contaminated as to be sources of dangerous infection to human beings, and other measures as in his judgment may be necessary. Originally passed in 1944, this provision has rarely been invoked, and never before to justify an eviction moratorium. Regulations under this authority have generally been limited to quarantining infected individuals and prohibiting the import or sale of animals known to transmit disease. Realtor associations and rental property managers of Alabama and Georgia sued to enjoin the CDC moratorium. The U.S. District Court for the District of Columbia granted the plaintiff's summary judgment, holding that the CDC lacked statutory authority to impose the moratorium. The CDC is an agency of one of the branches of government. Usually the executive branch is who can delegate their powers to an agency. So it goes all the way through the standard constitutional exploration of where did the agency get its power from, and did that power get granted appropriately? Does the executive branch have that power? So we have to evaluate then, where does the CDC's power come from, and do they really have the power they claim to have? But the court stayed its order pending appeal, meaning it did not enforce its order until the appeal was finished. It reasoned that even though the government had not shown a substantial likelihood of success, it did make a lesser showing of a serious legal question on the merits, which the court said warranted granting a stay when the remaining stay factors weighed in the government's favor. The D.C. Circuit Court agreed, though it rated the government's arguments more highly. This court, the Supreme Court, declined to vacate the stay. Justice Kavanaugh concurred, explaining that he agreed with the district court that the CDC's moratorium exceeded its statutory authority, but because the CDC planned to end the moratorium in only a few weeks, and because that time would allow for additional and more orderly distribution of congressionally appropriated rental assistance funds, he concluded that the balance of equities justified leaving the stay in place. Justices Thomas, Alito, Gorsuch, and Barrett noted that they would vacate the stay. The moratorium expired on July 31st, 2021. 3 days later, the CDC reimposed it. Apart from slightly narrowing the geographic scope, the new moratorium was indistinguishable from the old. With the moratorium once again in place, the plaintiffs returned to the district court to seek a vacatur, or to seek a vacating of its stay. The district court agreed with the plaintiffs that the stay was no longer warranted for 2 reasons. First, the government was still unlikely to succeed on the merits, given the 4 votes to vacate the stay in this court and Justice Kavanaugh's concurring opinion. Second, the equities had shifted into plaintiffs' favor. Equities would be the fairness of the thing. Vaccine and rental assistance distribution had improved since the stay was entered, while the harm to landlords had continued to increase. So it was no longer unfair to landlords when now tenants could get vaccinated and also seek assistance from these rental assistance programs, whereas I'm guessing the landlords could not. But the court concluded that its hands were tied by the law of the case in light of the D.C. Circuit's earlier decision not to vacate the stay. That denial was followed by one more stop at the D.C. Circuit, where that court again declined to lift the stay. Having passed through the lower courts twice, the plaintiffs return as applicants to this court to again ask us to vacate the stay. The district court concluded that the stay is no longer justified. We agree. The applicants not only have a substantial likelihood of success on the merits, it is difficult to imagine them losing. The government contends that the first sentence of 361A gives the CDC broad authority to take whatever measures it deems necessary to control the spread of COVID-19, including issuing the moratorium. But the second sentence informs the grant of authority by illustrating the kinds of measures that could be necessary: inspection, fumigation, disinfection, sanitation, pest extermination, and destruction of contaminated animals and articles. These measures directly relate to preventing the interstate spread of disease by identifying, isolating, and destroying the disease itself. The CDC's moratorium, on the other hand, the COVID moratorium, relates to interstate infection far more indirectly. If evictions occur, some subset of tenants might move to another state, and some subset of that group might do so while infected with COVID-19. So it's much more speculative. The injury or the risk is much more speculative. This downstream connection between eviction and the interstate spread of disease is markedly different from the direct targeting of disease that characterizes the measures identified in the statute. Reading both sentences together rather than in isolation, it is a stretch to maintain that the law gives the CDC the authority to impose this eviction moratorium. This sounds to me like the legal concept of proximate cause. If I'm driving down the road and I negligently rear-end your car on the highway, causing a collision, an accident, I'm directly the cause. I'm the but-for cause, the factual cause, and I am the proximate cause, the legal cause. The law recognizes that I have caused an accident and therefore I am liable. I'm directly the cause. If I am indirectly the cause, my accident causes someone a mile back to get stuck in traffic and miss their big meeting, and they don't get the promotion or they don't get the job or something worse. Getting stuck in traffic a mile back is not legally connected to my causing an accident a mile ahead. Sure, you wouldn't be late if I hadn't caused an accident. I'm the factual cause, but the law recognizes that at some point the chain of cause breaks, and we recognize this as legal cause, proximate cause. Am I the legally recognized cause of those cars behind me being late? No. The reason is, if we were to do that, it would create a cascading situation where everyone would be coming to court trying to blame everything on the thing that came before. Somebody had an accident ahead of me, therefore everything bad that happens to me is that person's fault. We would basically obliterate every single person who causes a major delay or cascade of horribles. So there has to be some cutoff where by driving your car, you take the risk. You didn't leave early enough. You didn't take a different route. You could have scheduled it on a different day. There's all these different explanations for which one of the things really is the cause. And now the but-for cause has been diluted with these other potential explanations. So rather than the courts having to evaluate all of that, we're really only going to evaluate the direct problems caused by an injury. So that's the doctrine of proximate cause. That's my bad summary of the doctrine of proximate cause. The court goes on, even if the text were ambiguous, the sheer scope of the CDC's claimed authority under the law would counsel against the government's interpretation. We expect Congress to speak clearly when authorizing an agency to exercise powers of vast economic and political significance. So this does go back to, did the legislature or the executive branch clearly create this power for this agency? That is exactly the kind of power the CDC claims here, vast power. At least 80% of the country, between 16 and 17 million tenants at risk of eviction, fall within the moratorium. While the parties dispute the financial burden on landlords, Congress has provided nearly $50 billion in emergency rental assistance, a reasonable proxy of the moratorium's economic impact. And the issues at stake are not merely financial. The moratorium intrudes into an area that is the particular domain of state law, landlord-tenant relationships. There's also people who are being evicted because this is sort of the more sinister part. Sometimes landlords evict people not because they didn't pay their rent, but because the landlord wants to take repossession of the property, fix it up, and re-rent it, or move in themselves, or sell it. And right now there's a housing, it's not a boom, there's a housing shortage for tenants and a housing boom for owners. So if you sell a house now, or if you rent a house now, or an apartment, you can probably get more for it than you would previously. So landlords are motivated to get the current tenant out and get in and get the more money part of it. They probably still owe the same on their mortgage, and maybe even less if they're on a variable rate because interest rates are low. So there's a little bit of personal gain in there. Other times, and probably the vast majority, are people who lost their jobs and couldn't afford to keep paying their rent and would have been evicted but for the CDC's eviction moratorium. Indeed, the government's read of the law would give the CDC a breathtaking amount of authority. It is hard to see what measures this interpretation would place outside the CDC's reach, and the government has identified no limit beyond the requirement that the CDC deem a measure necessary. Could the CDC, for example, mandate free grocery delivery to the homes of the sick or vulnerable? Require manufacturers to provide free computers to enable people to work from home? Order telecommunication companies to provide free high-speed internet service to facilitate remote work? They are asking the landlords to provide free housing. Although it's not entirely free, the unpaid rent still accumulates, and the landlord can sue in small claims court or in regular county court to have a judgment brought against the unpaying tenant, and then that tenant, even after they move out, will still owe the money. Of course, the tenant who can't pay is probably not going to be able to pay the judgment either, so the landlord usually doesn't collect the full amount. This claim of expansive authority is unprecedented. Since that provision's enactment in 1944, no regulation premised on it has even begun to approach the size or scope of the eviction moratorium. Well, no pandemic has approached the size or scope of this pandemic since 1944. And it is further amplified by the CDC's decision to impose criminal penalties of up to a $250,000 fine and 1 year in jail on those who violate the moratorium. Section 361A is a wafer-thin reed on which to rest such sweeping power. The equities do not justify depriving the applicants of the district court's judgment in their favor. Again, equities are fairness doctrines. The moratorium has put the applicants, along with millions of landlords across the country, at risk of irreparable harm by depriving them of rent payments with no guarantee of eventual recovery. I disagree a little bit. Irreparable harm is usually anything that can't be repaired by money damages. There's a little bit of controversy when you get a money judgment against somebody and they can't pay. Is that irreparable harm? I don't think it's irreparable harm if you get a money judgment, but the defendant can't pay, or the judgment debtor can't pay. Despite the CDC's determination that landlords should bear a significant financial cost of the pandemic, many landlords have modest means. That is true. That is true. And preventing them from evicting tenants who breach their leases intrudes on one of the most fundamental elements of property ownership, the right to exclude. And that's from a very fundamental property case called Loretto v. Teleprompter Manhattan Cable TV Corporation, which was about when cable TV companies put cable distribution boxes on apartment buildings. Do they have to pay for that? Well, the property owner has a right to exclude. That's part of the bundle of sticks, the burdensome bundle of sticks that is property law. One of those rights is the right to exclude. Among them, the right to tenancy, the right to alienation, to sell. But the right to exclude means the right to keep other people off your property. So if you're a landlord and you have the right to occupy the property, then that means you have the right to evict the tenant. You have to do so within your state's laws for evictions, and you have to do so within the provisions of your rental contract, of your landlord-tenant contract for that property. But once you have the right to do that, you do have the right, whether we like it or not, whether we think highly of landlords who enforce and evict against tenants who don't pay or can't pay. It's not really reflective of the reality of the legal system, where they do have the right to do it, whether it's nice or not. As harm to the applicants have increased, the landlords, the government's interests have decreased. Since the district court entered its stay, the government has had 3 additional months to distribute rental assistance funds to help ease the transmission away from the moratorium. Whatever interest the government had in maintaining the moratorium's original end date to ensure the orderly administration of these programs has since diminished, and Congress was on notice that a further extension would almost surely require new legislation, yet it failed to act in several weeks leading up to the moratorium's expiration. It is indisputable that the public has a strong interest in combating the spread of the COVID-19 Delta variant, but our system does not permit agencies to act unlawfully, even in pursuit of desirable ends. It is up to Congress, not the CDC, to decide whether the public interest merits further action here. And they cite to Youngstown Sheet and Tube Company versus Sawyer, a 1952 case, concluding that even the government's belief that its action was necessary to avert a national catastrophe could not overcome a lack of congressional authorization. If a federally imposed eviction moratorium is to continue, Congress must specifically authorize it. The application to vacate the stay presented to the Chief Justice by him and referred to the court is granted. And let's see who that is. It does not say which judges wrote this. which is weird. Normally it would say which judges wrote this, and we should be able to find that out. Here, the dissenting opinion is from Breyer, Sotomayor, and Kagan, so I'm guessing that's 6-3, that Chief Judge Roberts joined with the majority in denying the eviction moratorium. And the dissenters write, the CDC has issued an order that, in light of the Delta variant, temporarily prohibits certain evictions in high transmission counties through October 3rd. Today, this court, as an emergency matter without full briefing or argument, blocks that order by vacating a lower court's stay. I think the court is wrong to do so, and I dissent, writes Justice Breyer. We may not vacate a stay entered by a lower court unless that court clearly and demonstrably erred in its application of acceptable standards. Those acceptable factors are whether the stay applicant has made a strong showing he is likely to succeed, whether the applicant will be irreparably injured absent a stay, whether the issuance of the stay will substantially injure the other parties, and where the public interest lies. And I can kind of see where the court, the two different sides of the court, the majority and the minority, they disagree here. It does sound an awful lot like the government didn't have a likelihood of success on the merits, and that landlords would be irreparably harmed if you think that unpaid money judgments are irreparable injury. In my view, the courts did not clearly err for three reasons, says Justice Breyer. First, it is far from demonstrably clear that the CDC lacks the power. The current order is substantially more tailored than its prior eviction moratorium, which automatically applied nationwide. Justified by the Delta variant surge, the modified order targets only those regions currently experiencing skyrocketing rates. If a covered county no longer experiences substantial or high levels of community transmission, the order will no longer apply there. To illustrate the difference, when we denied applicants' last motion, fewer than 20% of the counties would have been covered under the modified moratorium order's criteria. Today, however, the figure is over 90%. So Justice Breyer is noting that that changed, that it previously would have applied to 20% of the counties because COVID transmission was down, but now that the Delta variant is spreading like wildfire, it is up over 90% of counties that would be covered by the moratorium. To be protected from eviction, the tenant must reside in a covered area and attest that they have used best efforts to obtain government assistance, that they have satisfied certain income requirements, that they are unable to pay due to a substantial loss of income, hours, work, wages, a layoff, or extraordinary medical expenses, that they will continue to use best efforts to make timely payments, and they have no other available housing options. Unlike New York's moratorium, landlords remain free to challenge in court the truthfulness of a tenant's declaration that he or she qualifies for the order's protection. So they could bring an eviction motion or complaint, and then in that complaint challenge the truthfulness of the tenant's attestation or declaration. The CDC issued this modified moratorium order pursuant to its powers under the Public Health Service Act that we just read it. The statute's first sentence grants the CDC authority to design measures that, in the agency's judgment, are essential to contain disease outbreaks. The provision's plain meaning includes eviction moratoria necessary to stop the spread of diseases like COVID-19. When Congress enacted it, public health agencies intervened in the housing market by regulation, including eviction moratoria, to contain infection by preventing the movement of people. If Congress had meant to exclude these types of measures from its broad grant of authority, it would likely have said so. Well, so you've got two sides of that coin. The majority says that Congress could have said so, and the minority says that Congress could have said so. They're just speaking about it from two different perspectives. The second sentence is naturally read to expand the agency's powers by providing congressional authorization to act on personal property when necessary. It could also be read to provide emphasis regarding particular enforcement measures. Applicants urge, and today's per curiam agrees, that the second sentence should instead be read to cabin the CDC's authority. Not only does that reading lack a clear statutory basis, but the second sentence goes on to empower the CDC to take other measures as, in its judgment, may be necessary. So this is like when you have a contract with someone and it says, I'll pay you upon receipt of the product to my satisfaction. And then it further goes on and says, my satisfaction is adjudged by me. And the parties agree that I'm going to be the one that judges whether I'm satisfied. So here it says the CDC may use its judgment as necessary. Furthermore, reading the provision's second sentence to narrow its first would undermine Congress's purpose. As a key drafter explained, the second sentence of subsection A was written not to limit the broad authority, but to expressly authorize inspections and other steps necessary in the enforcement of quarantine. The per curiam also says that Congress must speak more clearly to authorize the CDC to address public health crises via eviction moratoria, but it is undisputed that the statute permits the CDC to adopt significant measures such as quarantines, which arguably impose greater restrictions on individuals' rights and state police powers than do limits on evictions. Indeed, the current Congress did not bristle at the government's reading of the statute. In 2020, Congress extended the CDC's moratorium issued under Section 361 of the Public Health Service Act. In any event, lower courts have split on this question, and then they cite a whole bunch of split cases. At minimum, there are arguments on both sides. Certainly, this court did not resolve the question by denying applicants' last emergency motion, whatever one justice might have said in a concurrence. The scope of that challenged moratorium, the balance of the equities, and the public interest were all different. As is typical in this court's emergency orders denying extraordinary relief, we said almost nothing about our reasons for declining to act. Second, the balance of equities strongly favors leaving the stay in place. Balance of equities is balance of the fairness factors, and it's part of an injunction. Applicants say they have lost thousands of dollars in rental income. That injury is lessened by the moratorium order's directive that tenants have an obligation to make as close to full rent as possible, and to compensate for the shortfall, Congress has appropriated more than $46.5 billion to help pay for rent in arrears. So is it really irreparable injury if the landlords are supposed to be getting at least partial rent from their tenants, and those tenants are supposed to be applying for rent relief, which Congress granted? It's again two sides of the same coin. They're both valid arguments, and it's difficult to see which one is entirely correct unless someone has a crystal ball that can see perfectly into the economics currently occurring. And that's really not the way that works. We certainly get some hindsight, but it's difficult to say what's happening right now. It's the part of Heisenberg's uncertainty principle where you can't know an atomic particle's location and speed or velocity at the same time. I think that was Heisenberg. Correct me if I'm wrong. It may, as applicants say, take time to get that money. That is an injury, but compare that injury to the irreparable harm from vacating the stay. COVID-19 transmission rates have spiked in recent weeks, reaching levels the CDC puts as high as last winter, 150,000 cases per day. And they show a graph here. The little bubble here was the original wave, which we thought was terrible. And then here was the July spike. And then here was the winter of 2020. And then here is the spring of 2020. And now we have this Delta variant and a lot of unvaccinated people. That's where we are today. To date, the CDC estimates 38 million Americans have been sickened. This week, the CDC calculates average new daily hospital admissions at 12,000. The number of patients hospitalized is up 13.3% from last week. Look back at the order's criteria for temporary relief. The CDC targets only those people who have nowhere else to live in areas with dangerous levels of community transmission. These people may end up with relatives in shelters or seeking beds in other congregant facilities where the doubly contagious Delta variant threatens to spread quickly. If you're living in a housing facility where you have to live with other people, you can't keep your mask on all the time. You're going to have to eat, you're going to have to shower, and you're probably sick of wearing a mask in the first place and don't want to keep it on all the time. So those are going to be hotbeds for COVID spread, is what Justice Breyer is trying to say. He cites to the science, deltavariant.html on the CDC's website. You can see the link there, which says the Delta variant is more than 2 times as contagious as previous variants and may cause more severe illness than previous strains in unvaccinated persons. Absent the current stay, the CDC projects a strong likelihood of mass evictions nationwide with public health consequences that would be difficult to reverse. Third, the public interest is not favored by the spread of the disease or a court's second guessing of the CDC's judgment. The CDC has determined that a surge in evictions could lead to the immediate and significant movement of large numbers of persons from lower density to higher density housing, when the highly transmissible Delta variant is driving COVID-19 cases at an unprecedented rate. The CDC cites models showing up to a 30% increased risk of contracting COVID-19 for some evicted people and those who share housing with them after displacement. The CDC invokes studies finding nationally over 433,000 cases and over 10,000 deaths may be traced to the lifting of state eviction moratoria. The public interest strongly favors respecting the CDC's judgment at this moment, when over 90% of counties are experiencing high transmission rates. That figure is the highest it has been since at least last winter. It was in the single digits when we considered the CDC's previous eviction moratorium order and denied applicants' earlier motion. On applicants' last trip to this court, they argued that the downward trend in COVID cases and the effectiveness of vaccines left no public health rationale for the eviction moratorium. These predictions have proved tragically untrue. Today, they show just how little we may presume to know about the course of this pandemic. Applicants have raised contested legal questions about an important federal statute on which the lower courts are split, and on which this court has never actually spoken. These questions call for considered decision-making, informed by full briefing and argument. Their answers impact the health of millions. We should not set aside the CDC's eviction moratorium in this summary proceeding. The criteria for granting the emergency application are not met. I respectfully dissent, says Justice Breyer. So, it's still a final decision. The eviction moratorium has been invalidated, and there are only 4 states that have their own eviction moratorium in place, according to Wikipedia. Hopefully I'm wrong about that, and all 50 states put eviction moratorium in place or some kind of measure to deal with containing the spread of COVID-19, especially the Delta variant. But it looks like only 4 states have their own versions of eviction moratoria, and of those, I think 3 of them are tied to the expiration of the CDC's measures. So that sounds like it's the end of the eviction moratorium. Hopefully the situation doesn't go as bad as it sounds like it will, but I'm going to guess that it will get worse before it gets better. I hope it doesn't. Let me know what you think in the comments below. Do you agree with the majority, and why? Or do you agree with the minority, the dissent, and why? Thank you for watching. Special thanks to our top supporters in September: John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, ShadowTycho, Earthbound Star, PureMagma, Drew Hart, TechTechPotato, and Eric Tams. You can support Lawful Masses on patreon.com/ljfrench, sponsus.com/law, through YouTube memberships, or through Floatplane subscriptions. Join me for our weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all. Bye.